Google.
My lords, my lady, yesterday we were on section 10.3 and we were looking at ground 11 and in particular the question of reputation, and I had taken you through paragraphs 248 and 249 of the judgment, which is at page 69, and we just finished on paragraph 250 of the judgment over the page at page 70, where the judge concluded that the decision of Fancourt J, that's in the Sazerac matter, shows that in some cases it may be possible to invoke section 10.3 based on a reputation for a narrower category of goods than one mentioned in the specification. And the judge goes on to say, in my judgment, whether that is possible will depend inter alia on whether there is an identifiable subcategory of goods and the relative size of that subcategory compared to the category for which the mark is registered. And then he goes on to say, in any event, the size and scope of the mark's reputation is relevant to the question of whether a link will be made in the mind of the average consumer, giving rise to one of the three types of injury. And we say that, contrary to my learned friend's submission yesterday, the judge had a good legal basis for concluding that to have a reputation for a narrower category of goods, there had to be an identifiable subcategory. And that is because if you flick back to the quotation from General Motors, which is at paragraph 246, you'll see in paragraph 24, there's a reference to traders in a specific sector at the end of paragraph 24. And in paragraph 27, at the top of page 69, there's a reference to the market share held by the trademark. And of course, implicit in that is there has to be a market that you can identify. And in addition, if you look at paragraph 248, the citation from Sazerac, towards the end of that, the judge, Mr. Justice Fancourt, refers to the narrower field in which the mark had been used. And so those matters feed into, in my submission, the judge's conclusion that you have to have an identifiable subcategory of goods. And we say that is logical for the following reasons. First of all, because otherwise a trademark proprietor could simply define the market by reference to their own particular sales, which would always result in them getting enhanced protection by section 10.3. So my learned friend gave the example of wedding dresses, but I mean, wedding dresses is an identifiable subcategory. We say, consider, for example, something like green dresses with feathers on them. If I'm the proprietor of a trademark, I've got a mark for clothing, but all I sell is green dresses with feathers on, I can't come along to the court and say, well, look, I've got this amazingly strong reputation in green dresses with feathers on, therefore give me enhanced protection under section 10.3. And what it's important for the court to remember, which I'm sure my lords and my lady are very well aware of, you get your protection under section 10.1 and 10.2 in any event. So it's not as though the trademark proprietor without an enhanced reputation is being deprived of the possibility of enforcing their rights, but they're simply not getting the additional protection conferred by section 10.3, which requires this additional step of enhanced reputation. Secondly, General Motors makes it clear that in order to assess whether or not you've got the requisite reputation for section 10.3, you have to assess that by reference to market share, and you can only do that if there is an identifiable market. So in this case, for example, because the subcategory short films is not clear and identifiable, it is not possible to know what falls within it. So in particular, Instagram Reels and TikTok, are they part of the market or not? My learned friend presumably would have to say no because of his very narrow construction of short films. But the fact remains that the market would be defined very differently depending on what short films means and whether it has a clear definition. The third point or reason why we say that the judge's approach is logical is, again, in relation to General Motors. You have to identify who the relevant public are and who the average consumer is. And you can only do that if you know and can identify a specific market. Finally, the strength of reputation is a factor relevant to establishing a link, as the judge pointed out at the end of that paragraph 250. And you can't identify the strength of the reputation without considering it in the context of the relevant market. So we say that the judge's approach in paragraph 250 to the law was correct, and then he went on to apply it to the facts at paragraph.
Sorry, Ms. Lynch, before we leave this bit of law.
Yes.
I don't want to set hairs running, but can I just ask you a question about the legal history of this?
Yes.
Section 10.3 protection, because you've been calling it, which is, I know, a traditional name for it, enhanced protection.
Yes.
Because originally in the 1994 Act,
yes,
10.3 protection, enhanced protection, was only available against someone who was using the mark on goods which were not similar.
Exactly, my lord.
And
yes.
Forget about services for a second, just because it's easy linguistically. Goods that were not similar.
Yes, that's right.
Now, I can't remember two things. I can't remember, A, whether that was the same as the directive, and B, when it was changed, because that's not true anymore under the 1994 Act. It's not only applicable to cases in which the goods are not similar. There was a change to the law to give that what you're calling enhanced protection across the board. And I can't remember whether that was a change that was made at the European level, or whether it was a change whether the law had always been that in the European level, and it was only us, as it were, in the UK that changed our act. And part of the reason I'm asking that question is whether General Motors and Appellant was decided at a time when this law was confined to cases in which the defendant must have been one is presupposing a case in which the defendant is using it on goods which are outside the similarity of goods criteria or not, which might or might not have something to do with the definition of goods that you're talking about.
My lord, I may have to get back to you on this, but to the best of my recollection, the position was that it was always, at least under EU case law, something which applied to similar goods as well as dissimilar goods, and that UK law interpreted it consistently with that. And then I think, but again, I'll have to get back to you, that there was a change in the language, perhaps following the consolidated trademark regulation or the updated trademark directive. I can't remember, but I believe it arose from the case law. But we will get back to you on that for a proper answer. None of the other council are vigorously shaking their heads, but that may not be because they agree with me. So that would mean, if I'm right, that all this case law was at a time when that was the same as the approach that we have now.
Thank
you. So just coming on to paragraph 255, which is on page 72, we've already looked at this briefly, but just to show you now, in the second half of the paragraph, this is the judge's assessment and applying the law to the facts. He says halfway down, as explained above, the Sazerac case suggests that it may be possible to overcome the threshold issue of reputation by showing a reputation amongst a significant part of the public concerned with the subcategory of goods or services. However, for the reasons I've explained above, I do not regard short films as a proper subcategory of goods, Therefore, I do not regard Sills marks as having a reputation in the UK for the purpose of section 10.3. However, if they do, it's amongst consumers of short films, and I shall consider matters on that basis. Now, just to recall to my lords and my lady that, of course, the reference back to the reasons I've explained above, I do not regard short films as a proper subcategory of goods, is what we were discussing right back in ground one. The judge's reasoning that you'll recall in paragraph 60 to 62 as to why he said that short films isn't a clear category of goods. And it is particularly important in that context to recall that Sills' attempt to define the category at trial included these subjective things, such as production values, and they very much, again, steered away on appeal from saying anything about what their definition is. I mean, they still can't come up with anything. So we say that the judge was right to consider that you couldn't find a subcategory of goods, and therefore that Sill didn't have a reputation for the purpose of section 10.3. Now, as I understand it, Sill's final point under ground 11 is that the judge erred in his assessment of the evidence in relation to acquired distinctive character, and that is a point that they make in various places in their appeal and respondents' notice, and I'm going to ask my learned junior to deal with that point.
Yes.
My lords, my lady, Sill contends that the judge erred as a matter of principle in his assessment of the evidence going to reputation, in that he failed to give that evidence a balanced consideration. That point is set out in paragraph 50 of the appeal skeleton. This same challenge is also made by Sill in the context of ground 2, which is that the judge erred in his assessment of acquired distinctiveness of the 383 mark in the context of validity. That's the Shorts TV word mark. And secondly, in the respondent's notice at point 1, where it is said that the judge ought to have held that the 2018 marks were validly registered for the additional reason that they had acquired a distinctive character through use. I'm planning on addressing my lords and lady on the judge's assessment of the evidence only once, because the evidence relied upon was the same, both for reputation and for acquired distinctive character. Just to get the correct legal framework before looking at the judge's assessment of the evidence, can I ask the court to go to the passages in the judgment where the judge sets out the relevant law, starting at paragraph 246. And my lords and my lady have already looked at this passage. This is in the context of reputation, where the judge refers to Sky Kick and the citation from General Motors. And I'd just remind the court of paragraph 27 and the relevant factors that must be taken into account, namely the market share held by the trademark, the intensity, geographical extent and duration of its use, and the size of the investment made by the undertaking in promoting it. Then turning back to paragraph 126 of the judgment, which is on page 33 and 34, the judge set out the relevant legal principles for acquired distinctive character, and at Little Roman 3 on page 34, in assessing whether a trademark has acquired a distinctive character, It must be an overall assessment of the relevant evidence, which in addition to the nature of the mark may include the market share held by the goods, how intensive, geographically widespread and long-standing the use of the mark has been, the amount invested by the proprietor in promoting the mark, the proportion of the relevant class of persons who, because of the mark, identify the goods or services as emanating from the proprietor, evidence from trade and professional associations, and in some cases an opinion poll. And then at paragraph 127, the judge referred to the observation of Mr. Justice Jacob, as he then was in British Sugar, that in the case of common or apt, descriptive or laudatory words, compelling evidence is needed to establish that a mark has acquired the distinctive character necessary to function as a trademark. So when considering whether a reputation and acquired distinctive character has been established, the type of factors the court takes into account are the same. But there is one point of difference between the assessment of the evidence for the purpose of reputation and acquired distinctiveness, and that is the date at which those assessments need to be made. In this case, for the purpose of reputation, the relevant date is June 2021, and that's because reputation is part of the infringement analysis. But for the purpose of acquired distinctiveness in the context of validity, the relevant date is the 8th of February 2022, and that date corresponds to the date of the counterclaim. There is no dispute between the parties on this appeal that those are the correct dates, and it's important to have those dates in mind because a lot of the evidence in this case actually missed those relevant dates. Turning now to the findings that the judge made, and starting in paragraph 255 of the judgment, which is the finding on reputation. He says, I first need to consider whether Sills Marks had a reputation in the UK at the time Google commenced the acts complained of, i.e. June 2021. I have addressed Sills' use of its marks by that date above, and I'll come back to that. And the judge then goes on to find that the marks were not known by a significant part of the public concerned by any of the categories of goods or services, even the category of cinematographic films. I'm now going to show you how the judge made that finding. He deals with the facts in three places in this judgment. The first place is on page 19, starting at paragraph 63 of the judgment. So this is the section of the judgment where the judge is reviewing the evidence of use. Can I also ask my lords and my lady to have open Sills' skeleton argument at paragraph 50, because this is where they set out the points going to reputation that they rely on, and it's the same points that are relied on for acquired distinctive character. Before we get into the detail of this, there are two overarching points to have in mind. The first is that my learned friend doesn't actually identify how the judge went wrong. All the skeleton does is to recite all of the evidence that the judge took into account and then say that he should have reached a different conclusion. And that is obviously a very unpromising basis for an appeal. The second overarching point is that the judge's summary of the evidence was largely drawn from an agreed table of use that the parties produced at the close of the oral evidence at trial. That table of use is in the supplemental bundle behind tab 9, but I'm not planning on going to it, because Sill doesn't actually say that the judge ignored a piece of evidence from that table, or a particular piece of evidence was missed, and nor could they, because the detail contained within that table is largely reproduced in the judgment. So if my lords and lady have the judgment open at paragraph 63 and Sill's skeleton argument, the first point taken by Sill is the adoption of the name, and that is dealt with by the judge in paragraph 63. He noted that it was a relatively small operation. The next point taken by Sill is the Oscar-nominated short films release, and this is all dealt with by the judge at paragraph 65 to 68. The court will see from paragraph 65 that there was evidence about these releases in North America. That's plainly the wrong territory. Then at paragraph 66, the judge noted that the evidence relating to the release in the UK was surprisingly thin. And in fact, my learned friend yesterday referred on his feet to these film compilations having been shown in around 30 cinemas in the UK with around 900 tickets sold. What he failed to mention was that those figures related to the position in 2024. So that is after both relevant dates. And that was a point picked up by the judge in paragraph 66. Then there was evidence about branding on these compilations, dealt with the judge in paragraph 67, that dated in 2024, so again after both relevant dates. Then there was some evidence about promotional posters and trailers, but the judge noted in paragraph 68 that Sill didn't actually track which cinemas used that material. Then the third point taken by Sill is other production and distribution activities. That was all considered by the judge in paragraph 69. He noted that post-COVID, those activities had decreased in scale. Then the fourth point is linear TV channels. That was also a point that my learned friend made orally yesterday, but the evidence on that at trial was incredibly vague. There was a channel on Sky, I'm looking at paragraph 70 of the judgment now. There was a channel on Sky for a little over a year from 2008.
And then linear mean?
I'm
Linear
sorry?
TV. I'm showing my ignorance, no doubt. But what's you can tell me who Paul Gascoigne, the footballer, is next. But what does linear mean?
I believe it means not streaming.
Okay.
So they had this channel on Sky.
You mean it's not on demand?
Yes. Yes, that's right. So the channel was on Sky for a little over a year, from 2008, but there was no evidence about viewing figures for the Sky channel. The channel was on Amazon Prime from November 2020, so that is shortly before the relevant date for reputation. But again, no viewing figures for that channel in the UK. And then paragraph 71 of the judgment, in terms of branding, the position for the Sky channel wasn't clear. The Amazon channel had the 615, 649 marks visible, but of course there was no evidence as to how many people saw this because the viewing figures for the UK were not in evidence. Then the fifth point taken by Sill is the Amazon Video on Demand channel, and that was considered by the judge at paragraph 72 to 73. It was launched between October 2020 and January 2021, so shortly before the relevant date for reputation. But he found that there was surprisingly little evidence about its viewership. There were some subscriber numbers given for 2024, but that's obviously after both relevant dates. And then paragraph 73, he looks at the evidence of use of the marks, and he referred to the screenshots that were in evidence, but they were dated 2023, 2024, or undated. So again, that misses the relevant dates for both reputation and acquired distinctive character. The next point taken by SIL is the FAST and EST channels, the mobile app, social media and publicity at film festivals. That was all considered by the judge at paragraph 74 to 81. The FAST channel was launched after the relevant date for reputation, being late June or July 2021, and about 4 to 6 months before the relevant date for acquired distinctive character. The LG and Rakuten channels had very small reaches. I'm in paragraph 74 of the judgment. And there was no real evidence as to the viewership of the Samsung FAST channel. The judge dealt with EST content at paragraph 76 of the judgment. The only evidence of sales were from 2024, so after both relevant dates.
Do we need to know what EST, electronic sell-through, is? I mean, if it's after 24, it maybe doesn't matter, but
Well,
Very like
it's
linear, I don't know
irrelevant
what that
because
means.
it was dated 2024.
okay.
Then the mobile app was dealt with by the judge at paragraphs 77 and 78. It was launched in November 2021. That's after the relevant date for reputation. Some global figures were given for subscribers, but they were the wrong date because they were current figures and not focused on the correct territory. Then the YouTube channel is dealt with by the judge at paragraph 79 of the judgment. He noted that the marks don't appear on the channel itself, but only on the content that is displayed on that channel, if the content bears SIL's marks. There were again some figures given for subscribers, but they were at the wrong date and again not focused on the correct territory. There were no figures given for UK subscribers or views. Then social media was dealt with at paragraph 80, and that evidence suffered from similar problems in that the follower figures, which were tiny, I mean 1,200 on Instagram and 50 on TikTok, they were dated from 2024, so after both relevant dates, and there were no UK figures available for Facebook, Twitter or the LinkedIn accounts. Finally, the publicity at film festivals was dealt with by the judge in paragraph 81, and he found that the evidence about SIL's involvement at film festivals in the UK was vague. There was no evidence about use of its branding at those festivals before 2024. There was evidence that SIL had associations with film schools, but no evidence about use of its branding at such events. So in my submission, that is a very detailed and careful review of the evidence. And having reviewed the evidence, the judge then set out a summary of the evidential position at paragraph 128 of the judgment, which is on page 35. So this is now the second place in the judgment where he's looking at the evidence of use. It's important to note that in this paragraph, the judge is considering the position as at the 8th of February 2022 because he's dealing with acquired distinctiveness at this point in the judgment in the context of validity. But it's right to point out that that was actually an easier target for SIL to hit, in the sense that because the date was later, they ought to have been able to show more use. I'm not going to read through this whole summary, but it can be seen from this summary that there was no evidence about the number of people who saw the marks when viewing the Oscar-nominated short film compilations or on publicity materials. That's Little Roman 1. There were no viewing figures for the linear channels, Little Roman 2. The evidence concerning the fast channels was after both relevant dates, that's Little Roman 3. There was no evidence showing significant exposure to the marks through the EST channels, Little Roman 4. No evidence to show any significant consumer exposure to the Shorts TV Plus app before either relevant date or through social media activities. And there was no evidence about branding at UK film festivals and film schools or the reach of those activities. Then over the page at paragraphs 129 to 130, the judge considered the evidence from 4 of SIL's witnesses, and he rightly concluded in my submission at paragraph 131 that the problem with their evidence was that it was directed to knowledge of SIL rather than knowledge of SIL operating under the name Shorts TV or knowledge of its marks, and it wasn't really focused on the position in the UK. Since we're here, I'm just going to ask you to look at paragraph 132 of the judgment, because that is where the finding of acquired distinctive character is made in the context of validity. And if my lords and lady could just read that paragraph. Then the third and final place where the judge looked at the evidence is in paragraph 231 on page 65 of the bundle. And in this paragraph, the judge is summarising the evidential position as at June 2021. And that's because he's considering the question of acquired distinctive character in the context of infringement. And he says, I've summarised the use made of SIL's marks before the 8th of February 2022 in paragraph 128 above. By June 2021, the Amazon Prime channels had been running for only about 6 months. The fast channels hadn't started operation and the app had not been launched. In my judgment, by June 2021, the use that had been made of SIL's marks was not sufficient to give them enhanced distinctive character.
Ms. Bell, can you remind me what the significance of enhanced distinctive character is?
In the context of infringement?
Yes. Why is it relevant? Where does it fit? I've
Well,
forgotten.
it's part of the global assessment under section 10.2 and likelihood of confusion.
Thank you.
And that's why the date for enhanced distinctive character in the context of infringement is June 2021, whereas in the context of validity, it's the 8th of February 2022.
That's the date of the counterclaim.
Yes.
And the June 21 date?
That's the date the acts complained of commenced.
Okay.
Which is the relevant date for assessing infringement.
Oh, that's the launch date of the
Yes,
YouTube.
yes.
Okay,
And there's no
got it.
dispute between the parties on this appeal that those are the correct dates. So my lords and my lady, this part of Sill's appeal is an appeal on the facts, and as such my learned friend must satisfy this court that the judge was plainly wrong. And that means his decision is one that no reasonable judge could have reached. It is crystal clear from my learned friend's skeleton that the criticism they make is not that the judge failed to take into account a particular piece of evidence, rather that he failed to give it a balanced consideration. But they don't actually explain why that's the case.
Isn't it an evaluation rather than a factual decision?
Well, it's an evaluation made from primary findings of fact. And if I could ask my lords and lady to turn up Kynaston, which is behind tab 22 of the authorities bundle. If you could turn to page 616, paragraph 16, this sets out the correct approach on an appeal of this, by reference to what Lord Justice Lewison in Fage said. And if my lords and lady look at that internal citation at 114, appellate courts have been repeatedly warned not to interfere with findings of fact by trial judges unless compelled to do so. This applies not only to findings of primary fact, but also to the evaluation of those facts and to inferences to be drawn from them. And then over the page on page 617, there's a citation from Volpe, and at Little Roman 4, the validity of the findings of fact made by a trial judge is not aptly tested by considering whether the judgment presents a balanced account of the evidence. The trial judge must of course consider all the material evidence, although it need not all be discussed in his judgment. The weight which he gives to it, however, preeminently is a matter for him. And then Little Roman 5, an appeal court can therefore set aside a judgment on the basis that the judge failed to give the evidence a balanced consideration, which is what Sill is arguing on this appeal, only if the judge's conclusion was rationally insupportable. So rationally insupportable is the standard that my learned friend must hit on this appeal, and they just haven't grappled with that at all in their submission. This judgment is beyond reproach. It cannot be said that the judge his conclusion was plainly wrong. Quite the opposite. It was plainly right, because the evidence, such as it was really no more than mere evidence of use. There was no evidence of market share. There was no evidence of the intensity or geographical extent of the use in the UK. There was no evidence of amounts invested by Sill in promotion. There was no evidence from trade and professional associations. In fact, most of the evidence was after the relevant dates and didn't pertain to the UK. And those are two very basic points, the relevant date and the relevant territory, which the evidence in this case didn't even address. In my submission, that evidence would have been pretty hopeless, even if the marks weren't descriptive. But given that this was a case where the marks were descriptive, there really needed to be compelling evidence, and so it was completely hopeless. Therefore, in my submission, the judge's conclusion is not only one that was open to him to make based on the evidence, but one that was plainly right. Unless my lords and my lady have any questions, I'll hand back to my learned leader.
Well, Ms. Bogle, thank you very much. If you'll forgive me, I will make one other observation, which is that your leader, Ms. Lane, referred to you as junior, which you are.
Yes.
But as you were also, I hope, well aware, well, you obviously know, you are also one of this year's silks. And congratulations. Thank you.
Thank you, my lord.
Yes, we're all delighted about that. You'll be hearing a lot more from her in the future. I will come back when I'm doing the cross appeal and also the appeal on validity to explain how the submissions that my learned junior / about to be King's Counsel made, and explain where they fit in those places. But we reached them first at this point, which is in the section 10.3 context. The other ground in relation to section 10.3 is ground 12, which is that the judge erred in his assessment of dilution or detriment to distinctive character. And what I want to do is to take my lords and my lady first to the law in relation to that, which the judge set out at paragraph 253 on page 70 of the judgment. And so he starts by setting out the principles set out in the decision of W3, which was a decision of Mr. Justice Arnold, as he then was. And I just want to draw attention to, first of all, subparagraph 1, which is the more immediately and strongly the trademark is brought to mind by the sign, the greater the likelihood that the current or future use of the sign is detrimental to the distinctive character. Then point 2, the stronger the earlier mark's distinctive character and reputation, the easier it will be to accept that detriment has been caused to it. And then point 4, the more unique the trademark, the greater the likelihood that use of a later identical or similar mark will be detrimental to its distinctive character. And finally, at point 5, at the end of that paragraph, it says it follows that proof that the use of a sign is or would be detrimental to the distinctive character of the earlier mark requires evidence of a change in the economic behaviour of the average consumer of the goods or services for which the mark is registered consequent on the use of the sign, or a serious likelihood that such change will occur in the future. And he adds to that what was said in Planet Art, and that again emphasises at the beginning of the paragraph the need for change, actual evidence of a change in the economic behaviour of consumers, but says that it's difficult to obtain. And of particular importance in this case is the second half of what is said there, which is that where a rival creeps up on a brand, a proprietor is sometimes forced to edge away from the newcomer at some cost or devote resources to amplifying its brand message to avoid its original distinctiveness being drowned out by the alleged infringer. Now, I emphasise the point, amplify its brand message, because we say that is not what the other side is arguing in this case, and drown out original distinctiveness. And the judge went on to say, in my judgment, where the evidence taken as a whole shows that damage of that kind is sufficiently likely, it is a corollary of the statement of principle of the Court of Appeal that it's not invariably necessary for there to be actual evidence that consumers have changed their behaviour as a result. And so then, following on paragraph 34 of Planet Art, the other thing that the judge emphasised in that case was that just as in a case of infringement under section 10.2, so under section 10.3, descriptiveness of the respective marks is a key element. A trader has less right to complain that its brand is being diluted if it has chosen a mark which is of limited distinctiveness in the first place. Nor can a trader complain that precisely because its brand is so vulnerable to loss of distinctiveness and swamping by a newcomer using it descriptively, that this gives rise to a claim for dilution. So important to have in mind descriptiveness as well in the context of section 10.3 as in the context of section 10.2. So moving on to the short passage in the judgment that deals with this, which is at paragraphs 257 to 258 is the key reasoning. 257 sets out SIL's case on dilution. First, it said that it would reduce their capacity to act as a badge of origin for SIL. And secondly, it said that it would alter the meaning of the word short so that it came to mean user-generated content, which would make it harder to locate SIL commercially. So it had sort of two strings to its bow, but in fact, the first string to its bow is essentially repeating the meaning of detriment to distinctive character in different words. And notice that the judge doesn't refer in paragraph 257 to any evidence in support of this point, showing a change of economic behaviour, and SIL doesn't and didn't refer to any in its skeleton argument or in my learned friend's submissions yesterday. And indeed, I didn't really understand my learned friend to be pursuing this first point. As I understand it, the case is very much put now on the basis of the second argument, that it would alter the meaning of the word short so that it came to mean user-generated content. What the judge had to say about that is at paragraph 258. First of all, he notes in the second sentence that the distinctive character such as it is arises from the particular combination of the word shorts and the play symbol that I've referred to above. And it's important just because the judge is recalling again the fact that we're talking about a descriptive mark, and that's something you have to take into account according to Planet Art. Secondly, he goes on to say, I accept that Google's activities have had the effect of increasing the use of the word shorts for one type of short form audiovisual content, and so moving the centre of gravity of the use of the word shorts away from short films. That change in the weight of usage of the word may mean that SIL now has to explain its business more than it had to previously, but it does not mean that there has been an effect on the distinctive character of SIL's marks. And we say that that is absolutely correct because it's very different from the position as described in Planet Art of the situation where the proprietor is forced to edge away from the newcomer or devote resources to amplifying its brand message to avoid the original distinctiveness being drowned out. Instead, what SIL says it's having to do here is to devote resources to preserving the original descriptiveness of the word shorts, not the original distinctiveness of the word shorts, which of course we say it lacks. So we say that what is relied upon here is the opposite of taking action to re-establish distinctiveness. And so there is no error in this paragraph. And moreover, of course, this is the culmination of the multifactorial assessment that is required for section 10.3. And therefore, in order to overturn the judge on this point, it's not good enough to ask this court to undertake the balancing exercise afresh, which is what SIL seems to be asking the court to do. And you know, part of that balancing exercise is, for example, the finding at paragraph 256 at the end of that paragraph that although there's a link, it's a link which is less strong and immediate. And of course, as I went through in the W3 case back at paragraph 253, the problem is that you're likely to have a finding of detriment to distinctive character where you've got a unique trademark, and that is clearly not the case here. So we say that the type of damage that is relied upon is the wrong type, and we also say that yet again SIL doesn't address itself to the fact that it's challenging a multifactorial assessment, and so in order to do that properly on appeal it needs to come up with something other than saying, you know, let's have another go and try and get the Court of Appeal to come up with a different conclusion. So in conclusion on infringement, before I then come to...
It's striking, isn't it, Ms. Lane? I mean, the point Mr. Barlish makes is that what is a finding here is that his clients have got to do something as a result of what you lot have been doing, which at least at a higher level of generality is what 10.3 is meant to be protecting them from. Yes,
the problem is that the level of generality is so high that it ignores the fact that what the evidence has to show is that you've got to do something that's to do with the distinctive character of your mark, and they're not having to do anything to do with the distinctive character of their mark. They're having to do something which relates to the descriptiveness of their mark, and that's why we say this point doesn't run, because it's not damage to one of the functions of the trademark.
Okay.
And I mean, another point of interest in my conclusions on section 10.3 is, I mean, the judgment is quite short on this point compared to, you know, the extensive analysis on section 10.2, and my lords and my lady might be asking themselves why that is. And the reason is because this point was barely argued at trial. My learned friend didn't even address it in his oral submissions in closing to the judge. This is not one of those cases where the claimant came along to court and said, this is all terribly damaging to the repute of my mark, complete with evidence explaining why that was. That was not the nature of their case. They are now on appeal, obviously treating the trial as a dress rehearsal and saying, let's have another go. But that's not the way it works. And so both in relation to section 10.2 and in relation to section 10.3, we say that the court should be very slow indeed to overturn the multifactorial assessment, and that SIL has not come anywhere close to what they would need to do to show that that should be done on appeal. Now, if my lords and my lady don't have any other questions on infringement, I'm going to turn to validity of the 383 mark first of all. So that's my learned friend's appeal on the 383 mark, which is the one it's easier to remember because it's the word mark only. And the judge found that that was invalid for most goods and services. The challenge that is made is that the 383 mark did have a distinctive character, and in particular it said that the judge ought to have found that the mark was inherently distinctive, and if not, it said that he ought to have held that it had acquired distinctiveness through use. Now, my learned junior has already addressed the question of acquiring distinctiveness through use. I'm going to address the question of whether the mark was inherently distinctive, and we need to look in the judge's judgment at paragraph 93, first of all on page 27. And this is actually a citation post-Cantor case, and in this context, the point that we're looking at post-Cantor for is to do with assessment of descriptiveness of a compound mark. And at paragraph 98, it says, as a general rule, a mere combination of elements, each of which is descriptive of characteristics of the goods or services in respect of which registration is sought, itself remains descriptive of those characteristics for the purposes of Article 3(1)(c). So, of course, we say shorts is descriptive and TV is descriptive. Just because you put them together doesn't give you a distinctive mark. And post-Cantor says that there are two exceptions to this, and those exceptions are set out in the second half of paragraph 100 of that decision, and it starts about halfway down. It assumes either that because of the unusual nature of the combination in relation to the goods or services, the word creates an impression which is sufficiently far removed from that produced by the mere combination of meanings lent by the elements of which it is composed, with the result that the word is more than the sum of its parts. So that's one exception, if the combined word is more than the sum of its parts, or that the word has become part of everyday language and has acquired its own meaning, with the result that it is now independent of its components. In the second case, it is necessary to ascertain whether a word which has acquired its own meaning is not itself descriptive for the purpose of the same provision. And so that's the second exception, where it's acquired its own meaning. And the judge looked at these exceptions at paragraphs 111 to 112, which are on page 30. And he deals, first of all, at paragraph 111, and the first three sentences of paragraph 112, he's looking at the more than the mere sum of its parts exception. And he explains that, in my view, it does not. I'm reading from the middle of 111. There's not a perceptible difference between the word and the mere sum of its parts, or an impression which is sufficiently far removed from that produced by the mere combination of meanings lent by the elements of which it is composed. On the contrary, the impression given by the combination of shorts and TV is simply that the goods are shorts provided by televisual means, and that the services involve the provision of shorts by televisual means. And he goes on to say, Mr. Malinich submitted that shorts TV had unusual syntax, but I do not see why. He also submitted that consumers were used to TV channels being named XTV, where X was a reference to the type of content. That rather supports the view that there is nothing unusual about the syntax. So he's saying the first exception doesn't apply, and indeed it's really inconsistent with the second exception. And the second exception is addressed in the remainder of paragraph 112. Mr. Malinich's point was that consumers will take XTV as a reference to a channel, i.e. having a particular origin. However, while with use, consumers may understand XTV as a reference to the type of content to refer to a particular channel. That does not mean that without use they would assume it did, and the evidence did not establish that they would. So essentially, he dismisses the second exception, and in particular because he said that there isn't any evidence that it's acquired an independent meaning or a different meaning. And it's also important to look at paragraph 113, where he said that Google made the point that Sill's case was that use of the 615, 649 marks constituted use of the 656, 664 marks for the purpose of section 46. So this is a bit complicated. Section 46 is non-use, which is a different ground for invalidity, which we will come on to in the cross appeal. But in order to avoid that ground, what Sill did is say, well, I can rely on the use of shorts TV and say that that is good enough for the use of shorts because TV doesn't add anything to its distinctive character. And I think one can immediately see that that's rather inconsistent with their position, that shorts TV, the addition of the TV, does add something. And so we said that Sill had effectively conceded, I'm now back in paragraph 113, that the addition of TV did not confer distinctiveness. And the judge said, in my judgment, it is a matter for me to determine whether the addition of TV confers distinctiveness rather than to rely on implied concession. However, Sill did not have any effective answer to this point, and it's consistent with the view that I would have arrived at in any event. So it reinforced his view, the fact that they were trying to rely on it in a different context as non-distinctive, reinforced his view that the combination of shorts and TV was not distinctive.
Just given that we know that in some places in this judgment, the numerical references to the marks has been transposed, and it may not matter, but is this passage talking about use of shorts TV was use of shorts, or is it talking about use of shorts was use of shorts TV?
It's use of shorts TV constituting use of shorts, and I think we can see that if we go to paragraph 149. No, sorry, it's 153. He sets out, this is now the part of his judgment relating to section 46. And he says the ground that use of 615, 649, use of 656, 664. But I mean, I appreciate that given the problem with numbering, that might not assist, but
isn't that talking about the two pairs of marks?
well, the first part is talking about the two pairs. It's the second part. It was also common ground that use of the 615, 649 marks counted as the use of the 656, 664 marks. Although Google said that had consequences for validity as explained above. Does my lord see that?
Well, I do, but you see the end of the sentence says, if we call the two classes A and B, what that says there is that it was common ground that use of A was use of B, but use of B was not use of A. And therefore, and since I know that the judge transposed those numbers sometimes, I don't know which is A and which is B.
I mean, in fact, I don't think the last part of this sentence is correct. I think it was common ground that either way round. So maybe it doesn't help to refer to this part of the judgment.
It doesn't matter anyway, I don't know, but it occurred to me that I'd quite like to know which way round I thought it was.
Yes. What we can do, my lord, is perhaps look back at the opening and closing skeleton arguments and see if they shed any light. I mean, I don't need this point because I say, even if you just look at paragraphs 111 and 112, he's got the reasoning absolutely right. And I suppose we may, oh no, we're not going to see when we come to the non-use appeal because that's on a slightly different point.
Okay.
So just turning to what Sill's complaint is about the judge's finding at 111 and 112, it says that consumers have been educated to understand something which is a descriptive word plus TV as being a TV channel and therefore a trademark. And we say that is a finding on the fact, well, the judge found that that wasn't the case. He said the evidence didn't establish that. And so that is a finding on the facts that they are trying to overturn. And they have basically not got a good basis for doing that. I'll come in a minute to the one bit of evidence that they rely on. And then in relation to the other point, shorts TV has an unusual syntax. We say that that was rejected by the judge for good reasons, including that it's inconsistent with Sill's other submission relating to the fact that the evidence established that it has a specific meaning. So we say that they need to find, I mean, this is another evaluation on the facts essentially, or at least an inference drawn from facts, and so they've got to find a proper error. And the two points that my learned friend relied on in his submission were, first of all, the decision in SAT 1. So we need to have a quick look at that. That's in the Joint Authorities Bundle, tab 2. And at page 60, my learned friend pointed to paragraph 44, the frequent use of trademarks consisting of a word and a number in the telecommunications sector indicates that that type of combination cannot be considered to be devoid in principle of distinctive character. And we say that that quite simply is a finding which relates specifically to the facts in that case, and it tells you nothing about whether shorts plus TV has an unusual syntax. And indeed, if you look at paragraph 122 of the judgment, Sill tried to run this point at first instance, and the judge gave it short shrift. So paragraph 122 on page 33, he cites that paragraph and says that does not amount to a proposition of law. Each case needs to be assessed on its own facts. I mean, that's very clear in my submission. Not just what the judge said, but that he was right about that. I mean, you can't point out a single paragraph that actually is talking about a number with the word sat and say, oh, well, that means shorts plus TV. That has got a special meaning or an unusual syntax. Then Sill referred to the oral evidence in this case, and in particular, I think my learned friend on his feet referred to one of our witnesses talking about baby TV. And the problem with that, of course, is it's your classic example of island hopping. And the problem with island hopping, my lords and my lady will be well aware, is that once one person starts island hopping, the inevitable desire is to show you another bit of evidence which is very unhelpful to the other side. So I'm going to proceed to do that quickly. It's in the supplemental bundle at tab 15, page 194. And this is Mr. Pilcher, the leading light of Sill, giving evidence about why they chose the name Shorts TV. And if you have the transcript in front of you, if you could just read from page 134 at the top, the question is, and when you get to the fourth bullet point, that's when you're discussing the two words together, all the way down that page to it's descriptive of what we do, which is on line 3 of the next page.
So 134 of the little mini script.
Sorry?
Page 134 of the little square.
Yes, of the little square transcript to the top of page 135, line 3. So as you can imagine, we particularly liked the section of the evidence where he says that does what it says on the tin and it's descriptive of what we do. So, I mean, we're in the Court of Appeal now, my lord, so obviously we shouldn't really be looking at these things, but that is the problem with the other side starting to refer to the evidence in the case and saying that it shows that the name isn't descriptive. We say, well, even the CEO of Sill itself said the reason we picked it is because it's descriptive. Then there's another point that my learned friend makes, and perhaps I can say that it was made in a rather hand-wavy way, which is that it's descriptive of, even if it's descriptive of some goods, it's not descriptive of goods such as computer software. That was a refrain from my learned friend's submissions yesterday, and it's also a point that's taken in the skeleton argument. And it's quite important to understand the law on this and to understand why it is descriptive of computer software. And that requires, I'm afraid, looking at the judgment again at paragraph 86 in the core bundle, page 25. And we can just start quickly. I don't think my learned friend contested this point, but at paragraph 86, subparagraph 1, a sign is caught by the exclusion from registration if at least one of its possible meanings designates a characteristic of the goods or services concerned. So even if only some people understand it to mean short form audiovisual content, then that's good enough. But perhaps more importantly is over the page at paragraphs 91 and 92. And if I could just ask my lords to read paragraphs, and my lady to read paragraphs 91 and 92. So paragraph 91 is on page 26. So the point here is that you can't register a mark like Flying Scotsman, say, for books, not because someone hearing the word Flying Scotsman would think books, you know, it's another word for books, but because the word, because people might want to write books about the Flying Scotsman and call them Flying Scotsman in their title. And so you've got to be careful not to allow marks to be registered for carriers of content which are descriptive of something that might be carried, or the content. And that is what is being explained in paragraph 91. And it's setting out what the appointed person said in that case, Mr. Geoffrey Hobbs, KC, about how you work out whether that's a problem with the registration. You've got to look at whether the potential for goods or services of the kind specified to provide consumers with imagery or information about someone or something denoted by the sign is sufficiently real and significant to be a material consideration. And then you've got to look at whether it's reasonable to believe that the sign will actually be recognised by the relevant class of persons as descriptive. And paragraph 90.
Zane, sorry.
Yes.
I think I understand the point you were making about a carrier, like book.
Yes.
I'm bound to tell you, and I'm sure it's me, I don't see that jumping off the page out of that recitation of what Mr. Hobbs said in Flying Scotsman. I mean, I may be misunderstanding those words, but
I have to say I found that passage difficult.
I don't see that.
It is.
Mr. Hobbs is known for his clarity of expression. I don't know
Your example about the Flying Scotsman is clearer than
yes.
it's clearer.
Maybe I'm just missing something.
No, I mean, I may have introduced, well, I've introduced the word carrier into what I'm saying, and I'm now thinking, where did I get that from? It might be somewhere else in the Flying Scotsman decision itself, and maybe that's why I started using that word, partly because I thought it was clearer, because I agree just looks at that, then it's not crystal clear. Let me see if I can find the decision itself and see if that is more helpful in terms of explaining things.
No, he doesn't use the expression carrier.
No. I've come up with that on my own, I'm afraid. Or maybe it's because the judge uses it later on. I mean, in my submission, you can get it from the fact that the goods or services provide consumers with imagery or information about someone or something. An example, the classic example is a book that provides imagery or information about someone or something. Another example would be a video, for example. Perhaps it will make more sense when we get to the judge's application of this to the facts, but the important thing is that SIL doesn't take issue with this principle. This is paragraph 92, that the potential content or subject matter of goods and services could be one of their characteristics.
I mean, the point you're making, as I understand it, putting it crudely, is that a mark could still be descriptive of something, even if no one's actually used it as a description of that thing yet.
Yes.
Is it that, or is
Well,
it more, because you refer to computer software,
Yes.
are you saying it can be descriptive of what that particular computer software
Does.
in
Exactly.
terms of content?
Yes, exactly. It's more that point.
Okay. Isn't the word, I mean, the word potential you referred us to, as I understood it, was talking about the fact that that it's a potential thing that might happen in future rather than something that has already happened.
Yes, that's true. Yes. So it doesn't have to have done it already, but it might do it in the future. But that is in terms of not that it might become the word for computer software.
No,
But it,
sure.
yes, exactly. So moving on to where he applied this proposition to the facts, this starts at paragraph 94, and he starts by considering the 656, 664 marks, and so that's the shorts word marks, and obviously I think we've looked at this paragraph before. He explains over the page that shorts would be recognised by the average consumer as a description of a characteristic of goods, at least in the case of sound, video and data recordings, cinematograph films, etc. And then moving on to paragraph 97, he says that, well, that's sufficient to dispose of the allegation that the 656, 664 marks are objectionable under section 3(1)(c), because he's gone on to find that those marks have actually got a distinctive character. In case I am wrong, and because it helps to establish the groundwork for when I come to consider the 383 mark, I shall consider the position in respect of the other goods and services covered by the marks. So we're looking at this in the context of 383, but the reason I'm taking my lords and my lady to this part of the judgment is because he considers it first in the context of the other marks, in case he's wrong in his finding that they have got distinctive character. And he then goes through each of the different goods and services that are within the specification, and explains, this is where I've got carrier from, paragraph 98. I shall start with video and audio, tapes, cassettes, discs, etc. These are all carriers of audiovisual content. If the 656, 664 marks consisted exclusively of indications designating characteristics of the goods, then in my judgment, the potential for such goods to provide consumers with content which, on that assumption, they will recognise the marks as denoting, is, in my judgment, sufficiently real and significant to be a material consideration. So just unpacking that a bit, he is working on the assumption that those marks are descriptive, and he is saying that because these particular goods are carriers of audiovisual content, then the descriptive word shorts consists exclusively of descriptive matter, essentially, because the potential for such goods to provide consumers with content is sufficiently real and significant to be a material consideration. So basically he's saying, if you saw in a shop a CD now, or perhaps DVD, and it said Shorts on it, you wouldn't think, oh, Shorts is acting as a trademark. You would think Shorts is describing what is on this DVD. And that is why the registration can't be permitted, because it is descriptive of the content on that particular carrier. Does that assist, my lords and my lady?
And the real and significant bit, I know that's taken from.
Yes, that is taken from
Flying
Mr. Hobbs.
Scotsman.
Yes.
Is there any further origin of that in the case that seemed to be?
No, he
It's
comes
not
up.
obvious to me.
Well, Mr. Hobbs has come up with that two-stage test,
Yeah.
and that is the approach that he says has to be applied. I mean, there is other case law, for example, Lincoln Park, which my recollection is about, that was something in the trademark registry, where Lincoln Park, who are a pop group or possibly heavy metal, I don't know, were trying to register Lincoln Park for posters, and that was refused because the problem is people wouldn't look at a poster that said Lincoln Park on it and think that must be coming from a single proprietor. They would look at it and think that's a poster of a group that I want to hang on my wall, that the content relates to Lincoln Park, but they don't think it comes from a single source of origin. Does my lady see the distinction?
You said there was a two-stage test. I'm afraid I missed that. What's the two-stage?
Well, the two-stage test is back in paragraph 91. It's what Mr. Hobbs said in Flying Scotsman.
Mm-hmm.
So you've got to have the potential for goods or services of the kind specified to provide consumers with imagery or information about someone or something denoted by the sign is sufficiently real and significant. That's what I have rechristened, is it a carrier of content? And the second bit is it reasonable to believe that the sign will actually be recognised by the relevant class of persons as a description of the content or character?
I see. Thank you.
And so we say that in each of the paragraphs, well, we say first of all that the judge has looked at the descriptive nature in paragraph 94 of Shorts. And then in each of the paragraphs which go start at paragraph 98, he looks at each of the individual categories and it effectively applies that test, and in he applies it in relation to computer software, which is the one that my learned friend keeps complaining about at paragraph 99. And the problem with my learned friend's attack on this is that it doesn't really condescend to any detail about why he says the judge is wrong. He stands up and says, oh, well, you wouldn't think computer, Shorts was descriptive, or Shorts TV was descriptive of computer software. But you do need to get into the authorities because it is a slightly niche point. I mean, it's not as straightforward to understand as, Shorts TV for TV or television services or whatever. But nevertheless, we say that the judge's analysis is a good analysis, and he doesn't point out where the error is.
Just at 98, the judge holds that
Yes.
if the marks 656 and 664 were exclusively descriptive, my
Yes.
words, not his, which he held they weren't,
Yes.
if they were, then you can't have it for that class.
Yes, correct.
In 98.
Yes.
That's not quite what he did in 99. Can you just explain what he did in 99? Maybe it is what he did in 99, but there's more going on in 99.
Oh, well, 99, 99 is, 99,
Which is about computer software, which
Yes.
is what you were talking about a second ago, and why I was
yes.
struggling slightly, because
when those
Obvious to me
categories,
that whatever the judge did in relation to computer software is not the same as what he did in relation to CDs.
well, it's because what he is doing first of all is explaining that computer software is this enormously wide term, but included within that is computer software that allows audiovisual content to be played. So for example, on your laptop or your television or whatever, there's some software in it that allows it to be played. And because computer software includes software for accessing audiovisual entertainment, that is a carrier of content, in this case short films, that for which shorts is a descriptive term. And so that has the potential to provide consumers with content which they will recognise the marks as denoting. And that's sufficiently real and significant to be a material consideration. And just because there are other types of computer software that would be doing something completely different, that doesn't allow you to maintain the mark unless you're going to have some kind of fallback limitation, which I'm going to get onto.
So, yes, I suppose, how much of this is really about fallback limitation and how much is...
Well, fallback limitation is a sort of separate point that I'm coming to. As
Did the judge need, I suppose, can I put the question another way? Did the judge need to go for present purposes? Did he need to go through all these categories?
He did because unfortunately, well, the position that SIL took is our marks are valid in the current form, and then they had a fallback limitation. So they were putting before the judge the marks in their current form. And just to add to the complexity, I mean, this is all at the moment about 656, 664, but the reason we're talking about this is because we're talking about the 383 mark. And what I'm going to come on and show, just so that we can see where we're going, is that when we get to paragraph 114, because this goes on for quite a while, he says, this is where he deals with the 383 mark, which is the one I'm addressing. He says that's registered for many more goods and services than the 2018 marks, and I need to consider the extent to which the section 31C objection applies. That's the objection we're talking about. This is not an issue to which the parties directed any real attention in their submissions. In Annex 3 to this judgment, I've rearranged the order and have grouped some of the categories together, etc. And basically, one then has to look at Annex...
Yeah, before you,
3.
I'm sorry.
Before we get to that,
99,
right.
I still haven't understood paragraph 99. I'm sorry.
Right.
I'm not letting you get away yet.
Shall I have another go?
Well, no. So paragraph 99
Yep.
has a however sentence in the middle of it. So it says, the next group is software.
Yeah, and electronic entertainment software.
Yeah. When they're expressed in generic terms, it's not immediately apparent they have the potential to provide any short-form entertainment.
Yeah.
However, each category includes audiovisual entertainment access.
Yeah.
Then he says, which for reasons which will appear below is a subcategory of goods which in my judgment still is entitled, having regard to the use it made of those marks. So that's not the same as what happened in 98, paragraph 98.
No.
And then close brackets, then it says, for that subcategory of goods, the potential for consumers with content which they will recognise is sufficiently real. So I'm still not clear what is happening in paragraph 99. Is the judge saying that it is invalid for this category or valid?
He's saying it's invalid.
But only for a subcategory?
No, the difference here is that he's bringing in the question of non-use as well. Is that right? Sorry, my learned junior is going to tell me the answer to this. Yes, I mean, I hope I've made this point already, and it may or may not answer my Lord's question, but he's considering the question of whether or not they're carriers here, because he says that's not that it's not immediately apparent because it's such a wide category. And then he's saying that the category includes software for accessing audiovisual entertainment, And for that category, missing out the bit in brackets, first of all,
Okay.
but for that category, that they are carriers and therefore it's descriptive.
So that last sentence written in Hobbesian English is a distillation that it's invalid. That's
Yes,
echoing
it's
the same-
invalid,
it's
absolutely.
invalid.
It is invalid,
And
yes,
that's the subcategory.
yes,
It's
yes.
invalid for the subcategory.
Well, no, it's not invalid for the subcategory because the problem is,
It's invalid for computer software
Yes.
because it contains a subcategory.
yes,
for which
yes,
it-
exactly, exactly. And it's your fault for applying for such a ridiculously wide category that the whole thing
You can't have
goes.
computer software because within it there is a subcategory for which your mark is descriptive.
Yes.
Okay.
And I think the bit in brackets, although my learned junior is going to tell me if I'm wrong about this, is to do with the non-use part of the judgment.
But
And
the
that's-
conclusion, for the purposes of working out what the conclusion is,
Yes.
you can skip the brackets.
Yes, indeed. So
That's
that
what
it.
I've been trying to understand.
Oh, right, okay. I'm sorry it took me so
Well,
long
it
to get
seems,
there.
well, frankly speaking, what's in the brackets seems to be the opposite of what then follows the brackets. That's only my own simple mind, I'm sorry.
Yes, yes.
Is the bit in brackets saying that's the only bit you used?
It is,
But-
it is.
It's invalid anyway.
Yes. Although oddly,
Well, it uses
Not-
the word entitled. That's what I mean.
yes, indeed. What he's saying in that bit in brackets is you shouldn't have applied for the whole of computer software because you haven't used it for all of that. Maybe this will make more sense once we get to non-use. But the more straightforward point that I was trying to make is that the judge did go through the case law on this. There wasn't any dispute about that case law. I mean, it's not as though the other side says this case law about carriers, which is what I want to call it because it seems more straightforward, it is wrong. And, you know, the judge, I mean, they agreed that legal approach, even though my learned friend slightly seems to resile from it on his feet. And then he applied it very carefully to every single set of goods and services. And as I say, if my lords and my lady flick to Annex 3, which is at page 84, he goes through. In fact, let's go to the annex because the question whether or not it's valid is answered no, pretty clear for computer software. So at page 84, this is the 383 mark, which is the one we're actually talking about. It's just that I was showing you the reasoning in relation to the other marks because he says he applies the same reasoning. But perhaps I overcomplicated it because there are two columns, goods services on the left-hand side, inherent validity question mark on the right-hand side. And in relation to computer software, which is the third one down, the answer to inherent validity is no. And then he repeats the rubric about sufficiently real and significant.
Thank you.
Sorry, I probably set a hair running by not going to that table first. So apologies for that. So we say that my learned friend hasn't even started to show why this reasoning is plainly wrong. And then the next ground in relation to the 383, or sorry, the sort of sub-point in relation to the 383 mark is that it has acquired distinctive character. They say even if it's not inherently distinctive, it's acquired distinctive character. And my learned juniors addressed that already. Then we've got the fallback limitation, which is in post-Cantor, and again, this relates to the decision on the 383 mark, and in particular to the amended specification, which you can see at Annex 1 of the judgment. So that's at page 80 and 81. And so what they did was they added the words save for short films in some places and then deleted some of the references to short films.
So now the context is, we're now thinking about the 383 mark.
Yep,
The decision is that the 383 mark lacks distinctive character
yes,
in relation to the goods and services of its current registrations.
yeah, most of them, not all of them, a few were okay.
Yeah.
But they hadn't actually
And then
used it.
and then this is an effort to say, well, if you make these amendments to these
Yeah.
specifications, it'll be okay.
It'll be okay, yes, let's, as my lord said yesterday, I mean, the curiosity about all of this was that despite the fact that they say they're in the business of short films, they decided that the amendment to their mark would be to exclude short films. Now, the judgment in relation to this is at paragraph 136 on page 37. Or this is where the judge looks at the law, and he looks at a case called Amiga and Amiga that my learned friend mentioned in passing yesterday, and he sets out what he calls, what Mr. Justice Arnold, as he then was referred to as the post-cantor principle. Can I ask my lords and my lady to read paragraph 136 and paragraph 137, please? So I'm afraid that this is another slightly tricky point, at least as expressed by the CJU, which is that where registration is applied for in respect of particular goods or services, it cannot be permitted that the competent authority registers the mark only insofar as the goods or services concerned do not possess a particular characteristic. I think it's more straightforwardly explained in paragraph 137. And there's particular reference there to another decision of Mr. Hobbs QC. And the question is whether the limitation referred to characteristics that may be present or absent without changing the nature, function or purpose of the goods. And the specific example which makes it a little bit clearer is that Mr. Hobbs refused a limitation to the specification of goods in classes 18 and 25, which involved adding the words none being items of haute couture or not including items of haute couture. And the reason why you can't have that as a limitation is because that is just something that is present or absent without changing the nature, function or purpose of the goods. I mean, basically these...
Sorry, just again, let's make sure we're oriented. So you've got your trademark and you've got a specification of goods.
Yes.
Or services.
Yes.
And it says software.
Yes.
Maybe that's a bad example, but software.
Yeah.
What post-cantor is about, and Mr. Hobbs's decision is about, is whether you can insert negative, an exclusionary limitation. It's not just about amendments generally. It's specifically about saying you have a word like software and you want to add something like save for software, whatever.
Yes, I mean,
save for something. It's about negative limitations.
It's
and then the
not.
question is what?
It's not just about
No, it's
negative
not.
limitations.
Okay.
It's about because you can't express it in a way. I mean, we'd have to get into some other cases to get into the details of it, but it can also apply to something that's a sort of positive way of putting the same point.
Only insofar as or something.
Yes, yes, exactly. But essentially it's trying to stop people from excising something which they're just expressing by reference to the characteristics of the goods or services, because it says, I mean, this is the rationale set out in paragraph 115, that third parties would not as a general rule be aware that for given goods or services the protection conferred by the mark did not extend to those products or services having a particular characteristic.
Okay.
So it's sort of trying to avoid uncertainty for third parties. But I mean, the point.
What does it mean? Right now I'm sitting here looking at these words thinking I don't know what this means.
Well, I
Maybe
think.
the reference to certainty is clear because everyone's got a view about what who could, cure, might be. I mean, there's a different, maybe a more difficult dividing line.
Yes, certainty is important, and that's one of the reasons why the judge found that
Well,
the
he's-
limitation proposed was no good because of
The
short
Court of
films.
Justice referred to legal uncertainty.
Yes.
Because it's obviously what it was
Yes.
thinking about.
Yes, but there is a further element to it. It's not just to do, well, if we come to look at the judge's decision on the facts, there are two reasons why he refuses this limitation. And one is because short films are not a defined category, but the second is because the limitation identified a subcategory of goods or identified something that is merely a characteristic of the goods or services that could be present or absent without changing the nature, function or purpose of the goods, which is
How
what.
can a characteristic ever satisfy that, really? I just don't get that. I mean, if you said, I mean, just forgive me for trying to be in concrete terms, but
Yes, no, it is helpful, I agree.
Smarties just popped into my head for some reason.
Right.
Maybe I want a Smartie, I don't know. Smarties, does saying red Smarties, only red, so you've got a classification of goods. Is red Smarties, is that a category?
That would be a
which-
characteristic that may be present or absent without changing the nature, function or purpose of the goods. Because let's say the category of goods was sweets or Smarties, if that could be a category of goods, and you said we're going to have everything except red ones, that would be no good because the nature, function or purpose of the goods, i.e. eating sweets or having a sweet, would not be changed by their colour.
The nature, function, or purpose. Right. So give me an example of something that would change the nature, function, or purpose.
Well, I mean, we could go to some of the authorities that I'm conscious of time.
Yes, well,
But-
I am too. I'll forget it. Don't worry.
So let me see if I can remember the facts off the top of my head without going to the authority. There is an authority of Mr. Justice Arnold, or perhaps he was sitting as an appointed person, in relation to various financial services, and the limitation was that it was venture capital, limited to venture capital rather than all this wide group of goods or services. And he said that that was okay because venture capital is a specifically defined market sector, and also because it didn't fall foul of this problem that it was present or absent without changing the nature, function or purpose of the goods. But I mean, I absolutely appreciate that this is pretty difficult, and as the judge says at the beginning of paragraph 137, Mr. Justice Arnold went on to observe that the application of this guidance has caused some difficulty in subsequent cases. I mean, it is tricky, and it's not always easy to work out, why a judge has decided in one case one thing and something else in another
Okay.
case. So my lord is expressing an uncertainty which many other judges before have also expressed, but I don't think there's any real difficulty on the facts of this case. And so perhaps if I take my lord, now to the, and my lady, to the assessment, which is paragraph 138. And you'll see that at paragraph 138, we contended that the proposed limitations fell foul of the principles in post cantor, because first of all, they identified a characteristic of the goods or services rather than a subcategory. And also because there was no clear and consistent definition of short films. And then the judge says at paragraph 139, I agree with Google. And even if it was possible to define short films by their duration and their condensed narrative structure, purpose and format, in my judgment, those are all characteristics of the goods which may be present or absent without changing the nature, function or purpose of the goods. I mean, it's still a film, even if it's a short film, I think is the point. And then in paragraph 140, he also found against this limitation on the basis that even if it's possible to regard short films as a sufficiently clear and consistent definition of a subcategory, the proposed limitations do not go far enough, because the problem with the amendments is that they haven't been applied to a sufficient categories of goods and services, because it probably wasn't apparent when I briefly took my lords and my lady to the amended, the proposed amended specification at page 80, but for example, the limitation isn't applied anywhere in class 38, for example, broadcasting and transmission of television programmes. And we said, well, that was found to be, Shorts TV was found to be descriptive of that. And so you would have had to say, save for broadcasting and transmission of short films. So it was problematic on many levels. Including, obviously, about the failure to clearly define, which I've already taken my lords and my lady to paragraph 60 to 62 and have repeated again today, which is, what is the definition? I mean, they don't want to come up with one because it's very difficult to come up with a clear definition. So that completes the appeal in relation to validity of the 383 mark. I appreciate that there are some slightly tricky points in relation to validity of the 383 mark, but I just remind my lords and my lady that the judge does go through all the law very carefully, applies it to the facts very carefully, and my learned friend hasn't really attempted to grapple with the judgment. I mean, I am taking you pretty much for the first time to this reasoning, so it's not as though my learned friend has taken you to it and explained why it's wrong. So then I was going to move to the cross appeal unless there are any questions, and I can reassure the court that I'm going to be much quicker on this. So we're now talking on the cross appeal about the validity of the 2018 marks, and the first grounds, which are grounds 1 and 2, relate to validity under section 3(1)(c), and what we call the figurative fig leaf point, which is a rather memorable phrase of Mr. Justice Arnold, as he then was in a case called Starbucks. And I think it's simplest to explain this point by going to the Starbucks authority, which is in tab 11 of the authorities bundle at page 258. And on page 260, you can see the community trademark, which is an issue in this case, which is the word now, arranged with a star, with some lines in the shape of a star or sun shape emanating from the central letter O. And then I think we can move on to paragraphs 96 to 97, where the judge is looking at the question of whether the sign is registrable. And if I could just ask my lords and my lady to read paragraphs 96 and 97 of this judgment. So section 3(1)(c), which is the section of the Trademarks Act that says that marks shall not be registered if they consist exclusively of signs or indications which may serve in trade to designate the kind, quality, quantity, etc., contains the word exclusive. And so there has been some question over whether that means if you've got anything which is not totally descriptive, you can fall outside that section. And this judgment's referring to Article 7(1)(c). I mean, that's the same thing, but in European law. And what it is explaining is that even if you've got some kind of figurative character to your mark, that doesn't mean that you fall outside section 3(1)(c), because that is not sufficient, essentially, to allow you to register something which is otherwise completely descriptive. And if you go on to paragraph 116 to 117, this is where the judge deals with whether or not this particular mark should be permitted.
So it's just the bit you showed us at 96 and 97. One
Yes.
of the points that was being made is that there are two grounds of revocation,
Yes.
two tests.
Yes.
One's exclusively and the other's devoid of distinctive.
Yes,
character.
exactly.
And
Yes.
the point the judge was making in the first paragraphs you showed us is that sometimes the exclusively ground is used, but sometimes you get past exclusively because you've got a tiny little bit of something.
Yes,
and you
exactly.
fall down on the void of distinctive character.
Yes, exactly.
And
Exactly.
then you take us to where do you say 116?
116 and 117.
Thank you.
And in fact, what the judge finds here is that the CTM, which I showed you now with the sort of sun or star symbol rounded, is precluded from registration under Article 7(1)(c), because it would be understood as descriptive. And the judge says the figurative elements of the CTM do not affect this conclusion. But then in the alternative, if he's wrong about that, then it's devoid of distinctive character under Article 7(1)(b), which is the same as Section 3(1)(b). And then at 117, he gives the warning to trademark registries that basically they only succeeded in obtaining registration of the CTM because it included figurative elements, yet they are seeking to enforce the CTM against signs which do not include the figurative elements or anything like them. That was an entirely foreseeable consequence of permitting registration of the CTM. Trademark registries should be astute to this consequence of registering descriptive marks under the cover of a figurative fig leaf of distinctiveness and refuse registration of such marks in the first place. So Mr. Justice Arnold, as he then was, is making very clear his view that you shouldn't let these type of marks, which have merely a figurative fig leaf of distinctiveness, onto the register. His view is you should get rid of them under section 3.1c, but you could also get rid of them under section 3.1b. And this decision was upheld on appeal, and the summary of the law and its application to the facts on this point was approved, but there's not any sort of further reasoning on the point that it's relevant to go to. And the judge set out in his judgment at paragraph 87 and 88 some parts of Starbucks. He set out, this is page 25, the mark that I've shown you already and the reasoning at paragraph 116. And he also points out at paragraph 89 that that it was unchallenged on appeal, and that Mr. Justice Arnold adopted the same approach in Supreme Pet Foods, and indeed that the General Court in a case called Cafe Nero had also adopted the same approach, where Cafe Nero, written in black in a particular font with a blue background and so on, was held not to be distinctive because it did not convey an immediate and lasting impression which members of the public may retain. And then moving on to paragraph 90, there's a helpful reference again to the Flying Scotsman case, but for a slightly different point, which is to say that Geoffrey Hobbs QC in that case talked about whether the figurative content is insignificant in the context of the sign as a whole. And we say that's a helpful way of deciding, that's the end of paragraph 90, that's a helpful way of deciding whether or not something is a figurative fig leaf, to ask the question, is the figurative content insignificant in the context of the sign as a whole? And then the judge goes on at paragraph 93 to post cantor, and we've already looked briefly at this paragraph, but I want you now to look at paragraph 99 of the citation from post cantor, which I haven't yet taken my lords and my lady to, which is important because what the court is saying there is that when you look at the question of whether a combination is descriptive, you have to consider, I'm reading the end of paragraph 99, in the case of a word mark which is intended to be heard as much as to be read, that condition must be satisfied as regards both the oral and visual impression produced by the mark. So it's saying that you need to look at the different aspects of the impression in the usual way. And we say that's important when we come on to see how the judge dealt with this in relation to the 2018 marks. And I've already shown you paragraph 94, which is where the judge recognises that shorts is descriptive. And the critical paragraph that we criticise on the cross appeal is paragraph 96, where the judge says, that leaves the red triangle in the O. In my judgment, the triangle would be recognised by the average consumer as a play symbol designating a characteristic of the goods, namely that they can be played. So in other words, not only is shorts descriptive, but so is the play symbol. However, I need to consider the effect of the combination of the word shorts and the play symbol rendered in red and located within the O. In my judgment, the way in which the two elements are combined is such that the mark does not consist exclusively of indications which may serve to designate characteristics of those goods. The combination creates an overall impression which goes beyond a mere juxtaposition of two descriptive indications. And we say that the problem with this part of the judge's reasoning is that the judge does not refer back to the figurative fig leaf problem, if I can put it like that. He only talks about exclusively, and he doesn't consider whether the figurative content is insignificant in the context of the sign as a whole, and nor does he consider explicitly the oral and visual and conceptual characteristics specifically. In fact, we say it's pretty clear that in this paragraph he's only thinking about visual matters, and that means that he fails to consider that orally and conceptually the mark consists exclusively of descriptive indications, and we say that that is an error of law.
I mean, just on the oral, as in listening.
Yeah, listening, yes.
The law can't be that, whether you say it is, I don't know. If you have a word and you have some, I'm going to call it deliberately, call it significant figurative content
Yes.
around the word, none of which you would hear if anyone ever said what they could see written down, they would simply see a word. So orally, it's only ever the word. Are you saying that's determinative?
I don't say it's determinative, but I say that what the judge failed to do.
No, I understand you say you failed to do that, but I'm just
Yes.
trying to think about how far that goes with this, and I was thinking that, referring back to the bit of law you referred us to, that you need to take into account all of the things. It's not that if the law, it's not the law, is it? That if it falls down on one of them, it necessarily drives the conclusion. I'm talking about visual, oral, conceptual. You have to look at the whole thing and make a judgment.
You have got to look at the whole thing and make a judgment, and I accept that just because it falls down on oral doesn't mean that the mark is automatically lacking in distinctive character, but it's an element that you need to take into account. And
yes, you say that the judge there focused on visual only.
Yes.
At least have referred to the fact that you're not going to speak if you're looking at that orally. I hate that.
yes.
You wouldn't pick that up out of that.
And also conceptually, of course, we say that the play symbol doesn't really add anything conceptually, because that is, that goes hand in hand with shorts and the reference to short films or audiovisual content. Whereas, as I'll come to in a minute, which is the third problem that we say there is with the judge's analysis, is that is very different when you look at the mark or the sign Shorts TV Plus, which is something that the judge had to look at in the context of non-use. So let me come to that point now. And I'm afraid we need to understand a bit about the non-use argument.
So you're now finished on this part of the
No, this is another point that I say shows that the judge's reasoning in paragraph 96 is wrong,
I see. Okay.
because I say it's inconsistent with his reasoning on non-use. So if we go to paragraph 145, which is on page 40, you'll see that there's a reference to the law there, and this is the question of whether a mark's been put to genuine use. And at the end of that paragraph, it says, for these purposes, use includes use in a form differing in elements which do not alter the distinctive character of the mark in the form in which it was registered. So when you have a trademark, sometimes people don't use it in exactly the form it was registered. And the question is, if they've used it in a different form, is that good enough in order to get over an allegation of non-use? And at paragraph 149, the judge looks at the law on the application of section 46(2), which is what we've just referred to. And if you look at subparagraph 3, the normal approach to the assessment and comparison of distinctive character applies in this context. This is in the context of non-use. Accordingly, it's necessary to analyse the visual and oral and conceptual qualities of the mark as used and of the mark as registered to make a global appreciation of their likely impact. And then at paragraph 150, there's another long citation from a CJU, a General Court Authority, and in paragraph 27 of that, you can see that towards the end it says, in such situations, this is about a third of the way down, where the sign used in trade differs from the form in which it was registered only in insignificant respects, and the two signs can therefore be regarded as broadly equivalent, the above-mentioned provision envisages that the obligation to use the trademark which was registered may be fulfilled by furnishing proof of use of the sign which constitutes the form in which it is used in trade. And the reason I'm highlighting that is to demonstrate that this question about whether it differs in insignificant respects is remarkably similar, in fact I would say the same as the test that we were looking at the end of paragraph 90 about whether the figurative content is insignificant in the context of the sign as a whole. And so that's the law on that. Then if you go on to paragraph 154 at the bottom of page 43, you'll see that there's a dispute about whether the use of Shorts TV Plus, because that was a form in which the claimant used the mark, counted as use of the 615, 649 marks, which are Shorts TV, and I don't think there's a mistake there. And we contended that the addition of the plus altered the distinctive character of the registered marks because it was a prominent visual element, had conceptual significance in suggesting that something more is offered, and adds an additional syllable orally. And the judge found that he didn't agree with us, and he says it doesn't add anything significantly distinctive to the 615, 649 marks. Insofar as these marks have distinctive character, that distinctive character is retained rather than altered. And we say that that position and finding by the judge is flatly inconsistent with the judge's finding on the play symbol. And we also note that in that context...
This isn't an error of law, is it? This is a different view.
Well,
a different piece of fact.
Well, it's a different piece of, look, it's the other side say there's a different legal test. I've shown that's not right. They also say the facts are different, but the point is that the facts are different in our favour, in the sense that you'd be more likely to think that the addition of a plus did alter the distinctive character than the addition of the play symbol.
I think there may be scope for disagreement on that, but
Well,
that's not really the point. The question is whether the judge was entitled to reach a different view. I'm not quite sure what you're saying here. Is this really a point about underlining what you say was an error of approach in relation to the play symbol?
I mean, it shows an inconsistency, and so insofar as the other side say this is a multifactorial evaluation, and I have to, the assessment of distinctive character of the mark is a multifactorial assessment, and I have to show either an error of law or I think an inconsistent factor is one of the things that you need to show. I say that this shows inconsistency. I mean, I've got my errors of law anyway, because I say my errors of law are not looking at figurative fig leaf and failing to consider visual, oral and conceptual. But at the very least, I say it's extremely striking that in this context, he does consider visual, oral and conceptual, and he didn't do it in the context of the assessment of the validity of the marks. And I say that reinforces my point that, in fact, he should have done so. So just in summary, I mean, it is a very short point really, because there is only that one paragraph of reasoning that the court needs to consider, paragraph 96. we say that had the judge taken the correct approach, what he should have done at paragraph 96 is applied the test of whether the figurative content is insignificant in the context of the sign as a whole. He didn't do that. He should have applied that test to the visual, oral and conceptual impression of the mark. He didn't do that. He only did it to the visual impression. And had he done it correctly, he would have found that visually and conceptually, the play symbol simply reinforces the descriptive meaning of shorts and orally makes no difference. And consistent with his finding in relation to the plus symbol, found that it doesn't add anything significantly distinctive to the mark. And in relation to section 3(1)(b), we say that the judge should have considered that separately, and if he didn't find in our favour on section 3(1)(c), he should have found in our favour on section 3(1)(b), and it's worth just having a quick look at paragraph 123, because again we say that he places emphasis on the fact that, well, he says there's no independent basis for considering it to be objectionable. And I just want to mention the respondent's notice. And that has 3 points in it, and I just want to provide some signposting to the court in relation to those 3 points, because I don't need to make further submissions on them because they've been covered already. But point 1 is that the judge should have concluded that the 2018 marks were inherently distinctive, and we've already looked at that. And I think that point is basically only made in relation to the Shorts TV marks. And so it's the point that we've discussed already about unusual syntax and so on. The second point that's made on the respondent's notice is acquired distinctiveness, and my learned junior has addressed that already. And the third point that's made...
These 2 points are actually part of point 1, aren't they, in the respondent's notice?
Yes, they are. Yep.
They're both, yeah.
And then the third point is the post-cantor fallback limitation is made by way of respondent's notice, and I've already addressed that in the context of the 383 mark, but obviously we went through the reasoning in relation to the other marks as well. And so I can now turn to the final ground, which is the revocation of the 2018 marks for non-use. And that is pretty short, because it's kind of the other side of the coin in relation to our argument about inconsistency between the judge's decision on the significance of the play symbol and his decision on the significance of the play symbol and the insignificance of the plus symbol. And so we've already looked at some of the relevant paragraphs, but paragraph 145 is the one that I already referred you to, which explains the statutory provisions. And we've already looked at paragraphs 149.3 and 150, which explain what the test is. And then we've already looked at paragraph 154, which is where the judge came to his decision. about whether the plus altered the distinctive character of the marks, and found that it didn't. And we say that is inconsistent with the finding on the significance of the play symbol for the reasons I've already discussed in relation to that finding.
So was the only use that was relied on to defeat the non-use allegation was use of plus? I mean, not just plus, so marks
Shorts.
plus.
Shorts TV Plus. Well, it wasn't the only use, but it was important because it was the use that was relied on in relation to computer software and electronic entertainment software, and my lord can see that in paragraph 156 and 157.
So when at 155 the judge says the only categories of goods and services for which the allegations of non-use remain live, we don't have to be concerned with anything antecedent to that. So we're just concerned with whether computer software and electronic entertainment and electronic services, entertainment services, those three
Yes, yes.
are the only ones in issue.
Yes, because there was agreement in relation to the others. And I don't know whether my lords and my lady have noticed that in fact in the process of preparing for this appeal we realised that the order wasn't quite right, the schedule attached to the judge's original order, and because it didn't reflect the agreement that had been reached on the other categories of goods and services, and so that's been corrected under the slip rule.
So there is a category of goods and services that are where there's revocation for non-use.
Yes, I mean,
which is in the order.
yes, which is in the order, yes.
Right.
My lords and my lady, we rather cantered through the cross appeal, but as I made clear, it is my fallback case. And I just want to ask if there are any questions, otherwise I think I've reached the end of my allotted time and I should sit down.
No, thank you very much. Ms. Lane.
My lords, my lady, I'm not sure if it makes sense for me to address the cross appeal now or to pick it up after lunch, but I was going to address the cross appeal and then Mr. Malinich would address the response to Google's appeal. So there were originally 6 grounds for appeal, but ground 5 has been dropped. And before addressing the court on those grounds, I think it'd be useful to say something about the appellant's case on the interplay between infringement and validity. So to be clear that the appellant's case on infringement has nothing to do about airbrushing the stylized elements out of the marks whilst emphasizing those elements for the purposes of validity. There are a few separate but related grounds that mean that there's a likelihood of confusion in this case. So as Mr. Malinich submitted, the central error in this case relates to the judge wrongly regarding some of the respondent signs as purely descriptive. And what that means is that he failed to compare those distinctive signs, so the distinctive element shorts in our trademark with the distinctive element shorts in Google sign. So we say in circumstances where shorts is not descriptive in either mark or sign, then the fact that there are minor stylistic elements between them doesn't negate any kind of likelihood of confusion. And in fact, we go further and say that insofar as the appellant's place symbol in the earlier marks is a point of distinction as far as the judge is concerned, that exact same element appears in Google Signs. So there is a place symbol in some of the marks, there is a red place symbol. So insofar as that stylization is relevant, we say that that's actually in the appellant's favour. And so far as validity is concerned, as I'll come to, the judge rightly held that the appellant's marks are stylized. he probably had in mind and applied the law relating to the impact of stylization on descriptiveness and distinctiveness. And whilst he didn't say it in terms, he noted that the stylization was not a figurative fig leaf, and it was not inconsequential in the context of the marks as a whole. So the appellant's case on infringement and validity are, in my submission, entirely consistent. The respondent has adopted a bright line distinction between infringement and validity. The case on infringement requires it to emphasize the impact of the stylization in the context of allegedly descriptive marks. And then when we get to validity, again, it's to discount the stylization in the context of the same allegedly descriptive marks. So I understand the reason this distinction is because effectively the cross appeal is being run as a contingent point, but obviously our appeal and the response to the cross appeal are not being run as contingent points, and they operate in parallel. If I could address the court on grounds 1 and 2 descriptiveness. So the court has already been taken to the relevant passages of the judgment, and I can address the court briefly on them. But if I could please ask the court to turn to the judgment of the A bundle tab on page 24. So this is picking it up at paragraph 84. And this says, the language which the court will be familiar with, section 3.1c provides that trademarks should not be registered if they consist exclusively of signs or indication which may serve in trade to designate the kind, quality, quantity, intended purpose, etc., or other characteristics of goods or services. And at paragraphs 84 to 93, the judge set out the law on section 3.1c by reference to Mr. Justice Arnold, as he then was in Starbucks. And Starbucks itself cites the most authoritative case on descriptiveness and lack of distinctiveness, which is the CJU's judgment in Technopol. And the law is essentially uncontroversial, but there are a few points. So the first is that the judge's summary of the Technopol case at paragraph 85 shows that the descriptiveness objection needs to be interpreted in light of the general interest underlying it, and that's ensuring that descriptive signs are kept free for other traders to use. We can see that at paragraph 85 too. This is an obvious point because obviously no one should be entitled to monopolize a purely descriptive term. So for example, something like colored lasers for printers, because the mark tells consumers exactly how the printers work and what they produce. Second, as the judgment sets out at paragraph 86.2, there needs to be a sufficiently direct and specific relationship between the sign and the goods and services in question to enable the public concerned immediately to perceive without further thought a description of the goods and services in question or one of their characteristics. And related to those 2 points is the third point, which the court can see at paragraphs 87 to 90 of the judgment, and this is the extent to which visual content or stylization renders an otherwise descriptive word mark as non-distinctive. And as the judgment records in the final sentence, or the final 2 sentences at paragraph 89, it was not the appellant's case at trial, and it's not the appellant's case on appeal now, that exclusively means that a mark which contains any figurative element, in addition to a descriptive term, even though we don't accept that it's not inherently distinctive, disengages 3.1c. Rather, as the judgment notes at paragraph 90, which the court's been taken to, it's necessary to have in mind the observation of the CJU in Technopol, the public interest considerations behind section 3.1c, which is ensuring that descriptive signs relating to one or more characteristics of the goods or services in respect of which registration as a mark is sought may freely be used by all traders offering such goods or services. And then the judge goes on to say, in my judgment, that means that marks should not be permitted to pass through the section 3.1c hoop by means of the figurative fig leaf comment in Starbucks or Mr. Hobbs QC's comment in the Flying Scotsman, which is cases in which the figurative content is insignificant in the context of the sign as a whole. Now, I think it would be worth taking the court briefly to each of those judgments before addressing the court on the judge's assessment on the facts and why there is no appealable error here. If I could take the court to Starbucks, so this is in the Joint Authorities Bundle, tab 11, and picking that up at page 260, please. My learned friend took the court to a few paragraphs in this judgment, but there are a number of other paragraphs that I think helpfully shed light on the figurative fig leaf comment. So you can see at paragraph 3 there is the CTM community trademark, which is a stylized mark with the word now in lowercase letters with 6 fine lines arranged around the letter O. So the judge in that case had essentially described the mark as being minimally stylized. And before I go on, I should make clear that every case turns on its own facts, but the reason for going into this is to explain the context for the figurative fig leaf comment and why we say the judge correctly applied that principle in this case. Then if I can ask the court to turn to paragraph 28. So this is under the heading UKB service, and UKB is one of the claimants in that case. So the judge records at paragraph 28 that UKB was established in March 2003 to bid for regional wireless. It was originally called Netvigator. Then at paragraph 30, he makes the point that in mid-2005 UKB ceased to use the name Netvigator and decided instead to adopt the name Now. This decision followed internal assessment by 2 research agencies, Saatchi and Jam Consultancy. He then goes on to summarise all of that research on the name Now, and bearing in mind that at that stage there was no stylisation, so there was just the use of Now as a sign. And then at paragraph 37 says, the judge notes that Jam Consultancy concluded by cautioning that a brand with such a definite and descriptive name is demanding. So the judge goes on to say at paragraph 38 that UKB's service was then rebranded, and following the change of name now uses the logo that's shown there. So you can see there's Now logo with wireless broadband, but the claimant in that case used that logo without wireless broadband. And since a trademark that's registered in black and white protects all colours, the court can see that the origin of the brand usage of the mark that the claimant then went on to register as a CTM is as appears at paragraph 38. I've got another 10 minutes or so on Starbucks. I'm not sure if it makes sense to pause for lunch or to continue.
Okay, let's do that. We'll see you at 2 o'clock.
Court rise if able.